Hey, I'm Nancy Cavey. I'm a national ERISA disability attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. This podcast is not legal advice, but the Florida Bar Association says I've got to say this. So, as I always say, I've said it. But nothing prevents me on this podcast from giving you an easy to understand overview of the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So, ready? Off we go. In this episode, I'm going to talk about what you should do if your short-term disability insurance claim has been denied or your short-term disability benefits have been cut off before you've been paid all your benefits. We're also going to do some more myth busting, the myths that disability insurance policyholders believe about ERISA and individual disability insurance, and the truth. And the story of what one federal judge did about the short-term disability carrier's last-minute denial of benefits because the treating physician failed to respond to a call from the carrier's peer review provider. Stay tuned, and when we come back, we'll get to it.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
So what should you do if your short-term disability insurance claim's been denied or your short-term disability benefits have been cut off? Now, unfortunately, it's not uncommon for disability carriers to deny a short-term disability claim or to cut off a policyholder during the short-term disability period. Well, why do they do that? There's a reason behind this denial tool. Most policyholders have long-term disability insurance policies in addition to the short-term disability policy. And so if they pay you short-term disability benefits, that's going to create a pretty significant exposure to the long-term disability carrier. So by cutting you off, either while you are being paid those short-term disability benefits or denying your claim outright, is a tactic. They hope that you're going to get discouraged and that you won't file an appeal. They're also hoping that if they cut you off before the end of the short-term disability benefit period, that not only will you not appeal, but you also won't apply for long-term disability benefits. And that saves them a heck of a lot of money, doesn't it? So why do disability insurance carriers deny short-term disability claims? I think that disability carriers set up short-term claim denials to make it harder for you to get the disability benefits you deserve. And it's as simple as that. Remember, they collect your gold and then they rule that you're not entitled to your benefits. That's the disability carrier's version of the golden rule. Now, I found that HR reps, insurance agents, and inexperienced attorneys can make the mistake of telling you only to appeal the short-term claim denial. And then if the claim isn't paid, then you sue only for your short-term disability benefits. And in my view, as an experienced long-term ERISA disability attorney, I think that that's two big mistakes that you should avoid making. Now, worse yet, the issue can be complicated by the specific terms of the short-term disability plan or policy. Well, what do I mean by that? Well, sometimes the long-term disability policy will require that you be eligible for and be paid all of your short-term disability benefits before you qualify for long-term disability benefits. So if you don't appeal and try to skip go, you're not eligible for long-term disability benefits. Now, there are some times when the short and long-term disability plans aren't coordinated, but I still think it's important to proceed on both a short and long-term disability claim. Let's talk about the elimination period game. The long-term disability policy may have a separate requirement that you be disabled for a specific period of time, and that's called an elimination period. Now, some policies don't require that you be paid short-term disability benefits to be paid for long-term disability benefits, but they won't tell you that because they want to discourage you from appealing the short-term disability denial, hoping that you'll find an inexperienced ERISA disability attorney who will only take the short-term disability claim, and that you'll run out of time for filing the long-term disability claim, or make other mistakes. And clearly that's all a game. So in my view, what you should do if your claim has been denied is to do the following. I want to write a letter to the long-term disability carrier saying, look, our client's going to be applying for those long-term disability benefits, and I want you to send us a copy of the long-term disability application form. And why would I do that? Well, there might be a different carrier for the short-term and long-term disability policy. Or the employer may handle the short-term disability and then have a long-term disability carrier. And I find that generally they're not the same players for the short-term and long-term disability claim. And even if they are, they don't communicate with each other. So I want to write a letter to the long-term disability carrier saying, we're going to be applying for benefits, and give me that application form. And if they are going to play games, I always say, and by the way, if you're not going to send us these forms, I want you to consider this letter as our application for long-term disability benefits. Carriers might flat out refuse to send us the application for long-term disability benefits. They might refuse to accept our letter as an application, or worse yet, they might ignore it. So what happens if the short-term disability claim has been denied and we want to still proceed on a long-term disability claim, and they ignore it or say, heck no? Well, I think there are two ways to go depending on the policy language. If the policy language explicitly requires that the only way you're eligible for long-term disability benefits is to be paid all of your short-term disability benefits, then technically you or we need to win that short-term disability claim, or exhaust your administrative remedies on the short-term disability claim by filing an appeal. Well, why would we want to do what I'm suggesting that we're doing? I want to be able to sue the the disability carriers, be it short-term and long-term disability benefits, for your benefits. I want to sue them for both. I don't want to be hanging out here waiting for the short-term disability claim to be decided by the court and lose our opportunity or time to file for a long-term disability benefits. So I send the disability carrier a reminder that if the short-term disability benefits were paid, that the claim would roll over into a long-term disability benefit claim, because I want them to consider the claim on that basis. Or alternatively, I remind them that anything and everything we submit is to be considered as both part of a short-term disability appeal and a long-term disability claim. In other words, my appeal of the short-term disability claim is, in my view, a long-term disability claim application if they're playing games with me. So better yet, I will also submit an independent long-term disability claim. What do I mean by that? If the carrier won't give me their long-term disability application form, I just take a generic one off the internet and I fill it out and I say, I double dare you to deny it. And if they deny it, then I will take an appeal of the short and long-term disability claims. And when those are denied, if they're denied, then I'm going to sue both the short-term disability carrier and the long-term disability carrier. I'm not going to let them kind of divide and conquer and wear us out. We're going to go at them full guns, full barrels, and we're going to make them put up or shut up. So in my view, I don't take a short-term disability claim, the denial or termination, sitting down. To me, we need to get going on both that short-term disability and long-term disability claim. Got it? In the next segment, we're going to do some myth busting. If your doctor writes a note that you're disabled, the disability carrier is going to overnight you a check via FedEx. Stay tuned to learn the truth.